Report of the Center-State Relations Inquiry Committee, Government of Tamil Nadu, 1971, read by Ramani. Chapter 17, Interstate Water Disputes. Article 262 deals with the adjudication of disputes relating to waters of interstate rivers and river valleys. This article is entirely different from the corresponding provisions in the Government of India Act 1935, namely sections 130 to 133. Under section 131, it was the Governor General who had to decide interstate water disputes between the federating units. This decision was to be rendered after investigation by an expert commission. The Governor General had to exercise his discretion in the discharge of his functions under section 131. In the draft constitution, the provisions of section 130 to 133 were reproduced. There was also a provision in the draft constitution for obtaining the opinion of the Supreme Court on any question of law arising out of the report of the expert body. But subsequently, the present Article 262 was substituted for the provision originally proposed. Even at the time of the enactment of the 1935 Act, the then Madras government had intimated to the Reforms Office of the Government of India that it was desirable to give the federal court exclusive jurisdiction to decide inter-unit water disputes. They added that such jurisdiction should be widened to cover cases of agreement entered into even before the commencement of the Constitution Act, so as to include arrangements such as the 1892 agreement between this state and Mysore court, whose interpretation is a constant source of dispute. Unquote. This was reiterated subsequently in 1934. The Secretary of State suggested that the dispute should be settled by the Governor General, acting in his discretion with the help of a special expert tribunal. The government dealt with this point in great detail in their letter dated the 17th of March 1934, in which it was pointed out that it would be unusual in a federation and opposed to the very idea of a federal state that inter-unit disputes or disputes between the federal state and any of its units should be referable for decision to an authority outside the federation itself. This government said that the federal court should be the adjudicating tribunal in all disputes arising out of rights in water. The study team of the Administrative Reforms Commission for dealing with the center-state relationships has dealt with this topic. The study team has catalogued the reasons as to why the federal court should not be made the authority competent to decide interstate water disputes. The team had before it the views of the then Madras government communicated to the Reforms Office in connection with the enactment of the Government of India Act 1935. The study team gave the following reasons for not empowering the federal court in this matter. 1. Lack of any codified or settled law. 2. Prior to 1935, river waters were apportioned not according to legal right, but according to expediency. 3. Merger of erstwhile princely states and reorganization of states had resulted in certain decisions regarding sharing of waters, and these decisions may have to be reopened. 4. Sharing and distribution of waters should be based not so much on rights as on expediency. The then Madras government in 1934 favored the federal court and has dealt with the objections against this suggestion. It pointed out that the objection to the decisions of the federal court would be largely dominated by common law doctrines, could be eliminated if the Constitution itself specifically provided that such disputes should be decided on the principle of apportioning supplies in the most equitable and economical manner. As regards the second objection referred to by the study team, namely the arrangements in force before 1935 being upset, the then Madras government specifically stated that the agreements and treaties entered into before 1935 should be respected, although the question relating to their interpretation or their modification should be decided with reference to the principle of apportionment of water in the most equitable and economical manner. The study team of the Administrative Reforms Commission has, after consideration of the whole issue, favored the continuance of the existing arrangements under which interstate water disputes have to be dealt with under the Interstate Water Disputes Act 1956, Central Act 33 of 1956. According to that act, whenever a state government requests the central government to refer any dispute relating to sharing of water with another state, the central government has to constitute a tribunal if, in the opinion of the central government, it could not be resolved by negotiations. Tirugay, in his article mentioned above, has detailed the procedure to be followed in this regard. Article 262, read with Section 2 of the Act of 1956, ousts the jurisdiction of the Supreme Court and all other courts in relation to interstate water disputes. The position, therefore, is that no state can take the matter to any court, although Article 131 confers exclusive original jurisdiction on the Supreme Court in relation to other interstate disputes. Another point which arises in this context is as to how the decision of the tribunal given under the Act is to be implemented. Section 6 of the Act states that the decision of the tribunal is final and binding on the parties to the dispute, and that it shall be given effect to by them. The question still is, how is the decision to be enforced? It may be pointed out here that Section 17 of the Arbitration Act 1940, Central Act 10 of 1940, empowers the court concerned to pronounce judgment according to the award of the arbitrator, and upon the judgment so pronounced, a decree follows. In the absence of a similar provision in the Central Act of 1956, it is extremely doubtful whether the decision of the tribunal could be effectively implemented against a recalcitrant state. Tirugay, in his article, has tried to argue that Article 131 could be invoked subsequent to the decision of the tribunal. He states that the substantive rights between the parties having been adjudicated upon by the tribunal, the state acquires a legal right on the strength of the decision of the tribunal to have it implemented. The argument of the Union Law Secretary does not seem to be sound in view of the constitutional provisions and Section 11 of the Act. Section 11 is specific and categorical. It states that the Supreme Court or any other court cannot exercise any jurisdiction in respect of any interstate water dispute. This section, read with Article 262, must be construed to include the jurisdiction conferred by Article 131 also. Tirugay, aware of this position, concludes by saying that the purpose may well be achieved by duly amending Section 6 of the Act, Court, making provisions for settlement of the disputes relating to implementation of the decisions of the tribunal, unquote. The question is whether the present arrangements are capable of safeguarding the rights of the states concerned. As pointed out by the then Madras government in 1934, in all other federations, it's the federal court which has been entrusted with the function of deciding interstate water disputes. Under the 1935 Act, it was the Governor General who had to decide these disputes in his discretion with the help of an expert investigating body. Ad hoc tribunals lacked the power to enforce their decisions, and in the absence of a coordinating judicial authority, it may be difficult to evolve common principles applicable to these disputes. This committee therefore recommends that all disputes relating to interstate rivers should be decided by the Supreme Court and satisfactory provisions should be made for implementing its decisions.